During a recent press conference, the Department of Probation and Parole Services spotlighted the often overlooked but vital role of mediation in St. Lucia's justice system. Certified probation officers, trained in both civil and criminal matters, step in to resolve disputes on behalf of the court. With their expertise, these officers aim to settle conflicts efficiently and amicably, offering an alternative to the traditional legal proceedings. Acting Assistant Director of Probation and Parole Services, Jermaine Alexander, provided insight into the mediation process, which offers accessible and effective dispute resolution.
In layman terms, mediation is basically two or more parties sitting with a mediator, the probation officer, trying to resolve whatever issue that they may have. The resolution of those matters would come from the individuals. The probation officer, the mediator's function is that of facilitation, just facilitating the process, leading to a resolution. The legal framework that guides us, court-connected mediation, is Practice Direction number 2 of 2002 and Practice Direction 1 of 2003. Now, I must say that this is still in draft and it's on its way to full implementation in short order.
Alexander went on to highlight the benefits of this process.
Mediation is generally less expensive than a prolonged litigation, prolonged matter in court. It's also time-saving. It leads to quicker resolutions, often avoiding the lengthy court process that most persons would have to go through. And one of the key benefits that we often use in mediation and to bring to clients and the parties is that of control. When you have a matter before the court and before a magistrate or a judge, you have little or no say in the outcome of the matter. However, with mediation, you have more control over the outcome. Why? Because you are actively engaged in the process, and the outcome is totally dependent on you and the other party.
In providing a clearer understanding of mediation services, Alexander went on to explain the process in more detail.
The matter is referred to from the court, and the probation officers here, we would schedule a date and a time for the mediation, and parties come in for the particular mediation and that day and time. Very important as well is the matter of confidentiality. Whatever is discussed in the mediation remains in the mediation. It cannot even be mandated by the judicial officer to say that we must divulge what was said in the mediation. And why it's important is because this confidentiality allows parties to speak freely without fear of prejudicing their case that would be in court.
The Acting Assistant Director confirmed that as of 2024, the department has successfully handled around 430 mediations with an impressive 90% success rate in reaching positive resolutions. By reducing the workload on the court system, mediation provides a more accessible, efficient, and cost-effective alternative to traditional legal proceedings. Ultimately, it is a vital tool in creating a more harmonious society where disputes can be settled quickly, fairly, and with minimal friction, benefiting both individuals and the broader community. For Choice News Now, I am Direct Lionel.